Hello, I'm arbitrator Michael Loconto. Welcome back to the Labor Guild's series on labor law basics. Previous videos in this series discussed the rights of union members and the grievance process. In this video, we're going to discuss the National Labor Relations Act, or the NLRA. What is the NLRA? The NLRA is a federal law that enables workers to organize and bargain with their employer over working conditions. It establishes standards for employers and unions in collective bargaining and the workplace, and creates rights for unions, employers, and employees. How did it come about? The NLRA is a collection of several laws that have been enacted over the past 100 years. You may have heard of the Wagner Act, or the Taft-Hartley Act, or the Norris-LaGuardia Act. They're all here. Who is covered? The largest group of employees covered by the NLRA are working for private employers. These are what you might think of and are typical union workers, like steel workers, auto workers, or folks who may be in the building trades. It brings up images of factory workers in the 19th century. These are the stereotypical unionized employees. Who is not covered? The largest group of employees not covered by the NLRA are public employees, those working for state, federal, and local governments. These include public school teachers, public state college or university professors, and police or firefighters. Federal employees are subject to specific laws and utilize the Federal Labor Relations Authority and the Merit Systems Protection Board to enforce their rights. Furthermore, many states have their own laws that grant collective bargaining rights for public employees. For instance, Massachusetts General Laws, Chapter 150E, covers state and local employees. Public employees in Massachusetts enforce their workplace rights through the Department of Labor Relations, also called DLR, and the Commonwealth Employee Relations Board, or the CERB, C-E-R-B. In addition, employees in some industries have specific laws that govern their collective bargaining. For instance, the Railway Labor Act covers rail and airline workers. Employees covered by the Railway Labor Act enforce their rights through the NMB, or National Mediation Board. Certain agricultural workers are also covered by state and local laws in some locations. What does the NLRA do? The National Labor Relations Act provides a procedure for workers to organize a union and hold elections. If employees form a union, the Act provides a process to bargain with the employer over the terms and conditions of employment. The union and employer sign a collective bargaining agreement, also known as a CBA, that sets the terms and conditions of employment for the workplace. What are the terms and conditions of employment? Collective bargaining agreements, or CBAs, are complex documents that govern a variety of workplace issues. Pay, benefits, and hours of work are the classic terms and conditions typically found in a CBA. Other common provisions include definition of the bargaining unit, procedures for discipline and discharge, processes for promotions and layoffs, and specialized duties and pay incentives for certain positions and roles. The second video in our series discussed the grievance process, which is another feature of the CBA that unions and employers can use to resolve their disputes. The NLRA also includes strict rules that govern how unions and employers conduct themselves during bargaining. Employees have a right to engage in concerted protected activity, which includes bargaining collectively or simply advocating for a change in working conditions. For instance, a union might file an unfair labor practice, or ULP charge, if the employer refuses to bargain over a term and condition of employment. Where can someone file a charge under the NLRA? The National Labor Relations Board, or NLRB, is an independent federal agency that enforces the Act. The board is composed of presidential appointees from both parties and is headquartered in Washington, D.C. Board employees operate in regional field offices across the country. Region 1 is in Boston, and there are 31 other regions located across the United States. Eligible parties may file a complaint with the board online, which is then assigned to a regional office for investigation. If probable cause is established that the act was violated, the charge becomes a complaint. Federal, state, local, and industry-specific employees may also pursue complaints using the methods we discussed a bit earlier in this presentation. Who prosecutes NLRA violations? The board's general counsel acts as the prosecutor on charges. The general counsel directs staff and field offices, which include attorneys. Charges are typically heard first by administrative law judges in a regional office, and decisions by the ALJ may be appealed to the full board. Board decisions may only be appealed to the Federal Circuit Court of Appeals. Individuals may not sue for violations of the NLRA in court. Is the NLRA limited to unionized employees? The National Labor Relations Act governs a wide variety of workplace issues, and employees working in non-unionized workplaces may pursue complaints at the board, which is not exclusive to unionized employees. Recent board actions in non-union workplaces include the use of social media, the confidentiality of workplace investigations, and the use of non-disclosure, non-disparagement, and non-compete agreements. Join us to continue learning more about the world of labor and management relations through the Labor Guild's video series or by enrolling in the Labor Guild's School of Labor Management Relations. Courses are offered online in 4 sessions throughout the year and are taught by experienced labor and management professionals and neutrals. Visit laborguild.com for more information and to join or renew your membership. You can find a link in the description of this video. And please stick around and check out our other training videos. Thank you for watching.